undefined, unbounded, and immense power. That's what anti-federalists warned we'd eventually get under the Necessary and Proper Clause. And today, it's easily one of the most twisted and abused parts of the Constitution. So on this episode, I'm going to break down 3 key views of the Necessary and Proper Clause from the founding generation. We've got a strictly limited view from people like James Madison, Thomas Jefferson, and actually many others. There's a middle ground from one of the actual authors of the clause at the Philadelphia Convention, Edmund Randolph. And then we have the modern view, the one we live under today, which started with the big lie from Alexander Hamilton that was later reaffirmed by Chief Justice John Marshall. But first of all, before getting to that, welcome, and thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Monday, March 3rd, 2025. Let's get right to it. When the Constitution was being debated for ratification, anti-federalists repeatedly warned that the Necessary and Proper Clause might, could, or would likely lead to basically unlimited power. Here, for example, Brutus, in his first essay in 1787, he said, "This government is to possess absolute and uncontrollable power, legislative, executive, and judicial, with respect to every object to which it extends. For by the last clause of Section 8th, Article 1st, it is declared that the Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or office thereof." And Brutus was far from alone. Here, for example, John Williams, in the New York Ratifying Convention, said, "It is perhaps utterly impossible fully to define this power." They were trying to go through basically examples of how it might play out. And he said the number and variety of these cases are so endless that no man hath yet been able to reckon them up. And these are just a few examples, but this was basically repeated by anti-federalists over and over and over. And as a result, many of them probably agreed with old Whig, who wrote in his second essay that it was going to end up with undefined, unbounded, and immense power. He said, under such a clause as this, can anything be said to be reserved and kept back from Congress? He was saying, the way it's going to play out, they're basically going to claim power over anything and everything. He said, but to the question then, without force, what can restrain the Congress from making such laws as they please? Not in pursuance of the Constitution, but as they please. He said, what limits are there to their authority? I fear none at all. Now, in response to these warnings, predictions, concerns, claims by the anti-federalists, the Federalist side repeatedly held the line that the clause would add no new power at all. Here, for example, Archibald McLean in North Carolina, he said, this clause specifies that they shall make laws to carry into execution all the powers vested by this Constitution. Consequently, they can make no laws to execute any other power. Zero. This clause, he said, gives no new power, but declared that those already given are to be executed by proper laws. And even Alexander Hamilton, maybe the primary villain in this story, during the ratification debates was singing a similar tune to like McLean and many others. In Federalist number 33, discussing both the Supremacy Clause and the Necessary and Proper Clause, he made it very clear, absolutely clear, that neither of them grant any power. They are just purely explanatory. He said it may be affirmed with perfect confidence that the constitutional operation of the intended government would be precisely the same if these clauses were entirely obliterated, as if they were repeated in every article. In other words, you could attach both supremacy and necessary and proper after every article, probably every clause throughout the Constitution to reaffirm what they're being declaratory of, and it wouldn't change the power as if they weren't there at all in any place. He said they are only declaratory of a truth which would have resulted by necessary and unavoidable implication from the very act of constituting a federal government and vesting it with certain specified powers. James Wilson, who was way more influential on the ratification debates than Hamilton or anybody that we're citing so far. He was one of the first associate justices on the Supreme Court. Here he is in Pennsylvania, reiterating this. He said, "For when it is said that Congress shall have power to make all laws which shall be necessary and proper, those words are limited and defined by the following: for carrying into execution the foregoing powers." He said, "It is saying no more than that the powers we have already particularly given shall be effectually carried into execution." And then here from the so-called father of the Constitution, James Madison, Federalist number 44, he said, "No axiom is more clearly established in law or in reason that wherever the end is required, the means are authorized. Wherever a general power to do a thing is given, every particular power necessary for doing it is included." And that's how he's describing what the necessary and proper clause was meant to convey under the Constitution. Now, even Brutus, a number of times, but in this fifth essay, I think really acknowledged this, but his warning wasn't that, well, I'm arguing that legally it means different than what you're telling us. He's actually saying, well, maybe it's the same, but our concern is, how are they going to use this in the future? He said, "The inference is natural that the legislature will have an authority to make all laws which they shall judge necessary for the common safety and to promote the general welfare." And that's pretty much how it has played out. He said, "This amounts to a power to make laws at discretion." Now, laws at discretion is another term for, well, arbitrary power. Power, whatever government wants to exercise, it'll just do. And mind you, this is one of the so-called grievances. The injuries and usurpations in the Declaration of Independence was arbitrary power. So the notion just a little over a decade after, well, less than a decade, just a few years, but a little after a decade, over a decade after the Declaration of Independence, to establish a system that has one of the main problems that you cited in the Declaration of Independence was probably considered pretty nuts by some of these people. So he says this amounts to a power to make laws at discretion. No terms can be found more indefinite than these, and it is obvious that the legislature alone must judge what laws are proper and necessary for the purpose. But here's the kicker. He said it may be said that this way of explaining the Constitution is torturing and making it speak what it never intended. This is far from my intention. I shall not even insist upon this implied power. So he's not saying that this is what they drafted, this is what they intended, but he's thinking kind of long game. This is not how it's going to work in practice, despite what limitations you may be telling us about. And it didn't take too long for Brutus's prediction to come true, because in early 1791, less than 4 years after he was saying this in December of 1787, Alexander Hamilton decided he needed a new definition for the word necessary in order to claim that the national bank was somehow constitutional. And so this is how he put it in February of 1791. He said, "Necessary often means no more than needful, requisite, incidental, useful, or conducive to. It is a common mode of expression to say that it is necessary for a government or a person to do this or that thing, when nothing more is intended or understood than that the interests of the government or person require or will be promoted by the doing of this or that thing." Well, he's certainly changing the meaning of the word. I mean, I'm sure there's some examples of how necessary doesn't mean necessary, but it just means conducive to or useful to. And they were, these are a lot of legal minds that drafted this document, and they couldn't have just put conducive to instead. But Hamilton, that's how he wanted it. And so that's the case that he made. And then he took it even further. He kept going with it. He put it like this. He said, "The degree in which a measure is necessary can never be a test of the legal right to adopt it." And he's just saying, oh, well, this can't be part of the law. It can't be restrictive. We have to determine what's necessary, just like what Brutus was predicting in 1787. He said that must ever be a matter of opinion and can only be a test of expediency. He said the relation between the measure and the end, between the nature of the mean employed towards the execution of a power and the object of that power, must be the criterion of the constitutionality, not the more or less of necessity or utility. So he's just saying, well, if we decide we need to do this, then it's necessary. He said this restrictive interpretation, basically defining necessary as necessary, he said it is contrary to this sound maxim of construction, namely, that the powers contained in a constitution of government, especially those which concern the general administration of the affairs of a country, its finances, trade, defense, etc., he said they ought to be construed liberally in advancement of the public good. Sounds like a precursor to some really bad people we've heard of in more modern times. And he hammered it home with this. Again, just for the public good, construe it liberally, broadly as possible, and it can never be kind of a legal restriction on what government does. He said, if the end be clearly comprehended within any of the specified powers, and if the measure have an obvious relation to that end, not necessary, now just related to it, he said, and it is not forbidden by any particular provision of the Constitution, it may safely be deemed to come within the compass of the national authority. So for Hamilton, necessary did not mean necessary. It meant convenient, conducive to, or just related to. In other words, the federal government could basically justify almost anything at all. I should point out at this stage here that I'm citing a bunch of original source documents and I'm just scratching the surface. So we're going to include all of them in a show notes section for the blog post for this episode. Alan Mosley does an awesome job getting that organized. You'll find all the different platforms we're on, plus the show links, generally in the order of which I go through them in the episode. That way you can read and learn more in context on your own time. And I'll get that published over at 10thamendmentcenter.com/path to liberty. It's all spelled out. 10thamendmentcenter.com/path to liberty. We'll get that published a couple of hours after the live stream is done. So anyways, back to it here. Hamilton is making the case that necessary doesn't mean necessary in 1791 because he wants the power for a central bank. And so necessary means conducive to or convenient or just related to. And Thomas Jefferson warned, well, that's going to lead to basically unlimited power. Here's how Jefferson put it in 1791. He said, it has been much urged that a bank will give great facility or convenience in the collection of taxes. Suppose this were true. Yet the Constitution allows only the means which are necessary, not those which are merely convenient for effecting the enumerated powers. Again, if they wanted to say conducive to, they would have put conducive to in the document. Now, Jefferson doesn't make that case, but I think it's pretty clear that that's the position that he held. He said, if such a latitude of construction be allowed to this phrase as to give any non-enumerated power, it will go to everyone. For there is no one which ingenuity may not torture into a convenience in some way or other to someone of so long a list of enumerated powers. So we shouldn't be surprised when government looks at a power that's just convenient or conducive to or related to any of their other powers. They're going to find all kinds of ways to use that power, and eventually it's going to be unlimited. He said it would swallow up all the delegated powers and reduce the whole to one phrase as before observed. In other words, all you need for a constitution is just the necessary and proper clause, because that's how they read it. Everything else, what's the point of it if you're going to read it like this? Now, Jefferson continued explaining that his view of necessary means necessary. Therefore, he said, it was that the Constitution restrained them to necessary means. That is to say, to those means without which the grant of the power would be nugatory. Now, that's a kind of a natural reading of things. Hey, you can do this. You can establish a post office and do whatever is necessary to carry that out. He said, perhaps indeed bank bills may be a more convenient vehicle than treasury orders. He's not even like, he'll debate that a little bit, but that's not really the point here for Jefferson. He said, but a little difference in the degree of convenience cannot constitute the necessity which the Constitution makes the ground for assuming any non-enumerated power. Again, for Thomas Jefferson, arguing against Alexander Hamilton's National Bank in 1791, he's saying necessary means necessary. And James Madison, father of the Constitution again, he had a pretty similar take, also arguing against Hamilton's bank bill. He said, whatever meaning this clause may have, like, okay, we could debate all about this, but whatever it is, he said, none can be admitted that would give an unlimited discretion to Congress. So zero chance that they can have unlimited discretion to determine whatever is necessary or conducive to their own powers. He said its meaning must, and according to the natural and obvious force of the terms and the context, be limited to means necessary to the end and incident to the nature of the specified powers. So necessary means, well, necessary. Incident means incidental, not implied, incidental, lesser than the main power. He said, well, so let's say, for example, let's see if I can come up with an analogy here. You hire someone as an agent to run your corner store, and it sells snacks and drinks and stuff like that. Well, they decide that, well, it's necessary and proper that they run a tow truck business. So they take a loan out or a mortgage out on the property, and they buy a tow truck company because sometimes people park out in front and they block the entrance to the store. Well, that's not an incidental power. I'm not sure if that's a good analogy, but that's my quick take on it. Anyways, Madison goes further. He said the clause is in fact merely declaratory of what would have resulted by unavoidable implication. Sounds like what Hamilton said in Federalist 33. He said, as the appropriate and as it were technical means of executing these powers. He said, in this sense, it had been explained by the friends of the Constitution and ratified by the state conventions. And I'll get to that a little bit more near the end of the show here. But basically, the way we understand the real legal meaning of any legal document, and for this situation, we're talking about the Constitution for the United States, is to understand how the people who gave it legal force understood it. And for the Constitution of the United States, that's the ratifiers, the people of the several states. So Madison is making the case, like, look, this is the description of how the necessary and proper clause is supposed to play out, what necessary means. This is how the advocates of the Constitution sold it to the ratifying public, and this is how it is explained and then ratified by those people, those state conventions. So that is the legal meaning of the necessary and proper clause. So anyways, Madison goes a little further. He said, the essential characteristic of the government as composed of limited and enumerated powers would be destroyed if instead of direct and incidental means, any means could be used, which in the language of the preamble to the bill might be conceived to be conducive to the successful conducting of the finances, or might be conceived to tend to give facility to the obtaining of loans. So he's just citing Hamilton's bank bill right from the preamble to it and pointing out that they're trying to give facility, or it's conducive. These are the terms that Hamilton probably prepped in advance to make this case. Then Madison compared those terms with the terms necessary and proper used in the Constitution and asked whether it was possible to view the two descriptions as synonymous, or the one as a fair and safe commentary on the other. So he made the case, again, that this view, this conducive view, this convenient view from Alexander Hamilton would give unlimited power. He said, if, proceeded he, Congress, by virtue of the power to borrow, can create the means of lending, and in pursuance of these means can incorporate a bank, they may do anything whatever creative of like means. Anything whatever. Necessary and proper is quickly redefined by tyrants to mean anything and everything. So we shouldn't be surprised that we live under the largest government in history because the Hamilton view won out. I'll get to that a little bit more in a moment. Now, Edmund Randolph, one of the prime drafters of the clause, actually gave a little bit more of a nuanced view. He took a bit of a middle ground. He was saying basically that necessary didn't mean absolutely indispensable, but it also didn't mean that Congress could do whatever it decided was convenient. Here, for example, this is also his argument against Alexander Hamilton's bank bill in 1791. He said, to be necessary is to be incidental, or in other words, may be denominated the natural means of executing a power. He said the phrase, and proper, if it has my meaning, does not enlarge the powers of Congress, but rather restricts them. Now, Randolph's opinion holds quite a bit of weight because he's one of just a handful of people in one of the committees in Philadelphia who actually drafted the clause. And he was also one of the top legal minds of the time. He was George Washington's first attorney general. So he held a lot of weight when it comes to legal views. Now, that doesn't mean he took the Hamilton view. Again, he argued against it. But notice he didn't say implied power. He said incidental power. And Randolph, again, was a highly skilled legal mind, a highly skilled lawyer. He knew what he was talking about and what he was referring to when he meant incidental. And same with James Madison just a little earlier. He was referring to the old agency law doctrine of principles and incidents. And here, just a quick overview of that. If you want to get deep into it, there's going to be some links in the show notes at 10thamendmentcenter.com/path-to-liberty. But basically, it had to hit certain requirements. First of all, it was subsidiary to, or less important than a listed or principal power. Founding era lawyers said an incidental power had to be less worthy than the principal. That's how they described it. Or number two, it was either a customary way of exercising the listed power or reasonably necessary to its exercise. And this is how the Randolph view is broader than what Jefferson and Madison were saying. Jefferson and Madison, and actually most of the Federalists were saying. They were saying it had to be absolutely necessary, just meant necessary. Now, he's saying necessary in kind of the doctrine, the legal doctrine of what he understood was reasonably necessary. You didn't have to say, well, without this, we couldn't carry out the delegated power. It was just had to be reasonable. Founding era lawyers summarized reasonable necessity by saying that an incidental power had to be one that, if absent, would subject the exercise of the principal power to great prejudice. In other words, it would be pretty difficult to carry out, but not impossible, not nugatory, like Thomas Jefferson put it. So that's the middle ground. But again, it's not implied power. So Randolph's view had a little bit more wiggle room, maybe a lot more than Jefferson and Madison. And maybe if we had the Randolph view, we'd end up in the same place as we are today. Maybe it would be later on, maybe the same, but it was still nowhere close to what Alexander Hamilton had to say. And here's how he put it. As the friends to the bill, talking about Hamilton's bank bill, ought not to claim any advantage from this clause, so ought not the enemies to it, to quote the clause as having a restrictive effect. So he's being very clear. Like, look, the Hamiltonian people, they're wrong. The Jefferson-Madison people, they're wrong. But he definitely was more on the side of Jefferson and Madison because he's still arguing that the necessary and proper clause did not authorize the national bank. He said, however, and he said the Hamilton view would lead also to unlimited power, just like the anti-federalists warned how it would play out. He said, however, let it be propounded as an eternal question to those who build new powers on this clause, whether the latitude of construction which they arrogate will not terminate in an unlimited power in Congress. So this is one of the guys who drafted the necessary and proper clause, one of the lead attorneys, the lead lawyers who actually put it together. He's explaining it, and he's saying this Hamiltonian view, well, aren't you concerned that this is going to give Congress unlimited power? So for Randolph, necessary means kind of necessary. It really means incidental, but there's also a little bit more, and maybe that's the vagueness that the anti-federalists were so concerned about over and over throughout the ratification debates. Now, hear from Rob Natelson in his 80-page law review paper that I think you should read if you really want to get into this, The Agency Law Origins of the Necessary and Proper Clause. He did some research on how the word necessary was used at the time of ratification. And he points out, well, just one example. There are many of it like this. The leading dictionary of the time, he's talking about Samuel Johnson, lists multiple entries for the word necessary, but not a single one of these entries comes close to expedient, convenient, or useful. And I think that's a pretty interesting find because Hamilton is making the case that it's just common use of the term to say convenient, conducive to, related to, whatever it may be. And if you pull up the dictionaries that the average people used at the time, the most popular one, there's no definition that's even remotely close to that. So that means Alexander Hamilton was lying. His take that necessary just often means convenient rather than just maybe some legal definition that he was trying to use. This is just a blatant, outright lie. And despite that, Chief Justice John Marshall, years later in 1819, decided to run with that lie in the case of McCulloch versus Maryland. Here's how he put it. And some places he almost copied Hamilton verbatim. He said, "Does it always import an absolute physical necessity so strong that one thing to which another may be termed necessary cannot exist without the other? Well, food is necessary for my life. I can't live without it." That's another analogy that maybe sounds too simple, but a word means what the word means. He said, "We think it does not. If reference be had to its use in the common affairs of the world or in approved authors, we find that it frequently imports no more than that one thing is convenient or useful or essential to another." Can you imagine raising your kids and you're telling them, "Oh, it's necessary that you get your homework done." And they're like, "Yeah, well, if it's convenient to my lifestyle." I mean, this is the mentality that Chief Justice John Marshall, copying Alexander Hamilton, wants us to live by. That's not a really good standard. And here's where he really goes Hamiltonian, if he hadn't already. He said, "To employ the means necessary to an end is generally understood as employing any means calculated to produce the end, and not as being confined to those single means without which the end would be entirely unattainable." So anyway, however you can get there, that's cool, is Chief Justice John Marshall. And that's the precedent that the monster state of today, the largest government in history, follows. And I'm sure they're going to probably try to expand on it more and more and more in the future. So really, that's been the foundation for the largest government in history. People tolerating this, not being aware of what the original legal meaning of the clause is, and then deferring to the legal experts on some probably very difficult legal doctrine, necessary and proper principles and incidents. We don't learn about this stuff in school. So to recap, we have three main views of the necessary and proper clause from the founding generation. One, necessary means necessary. Basically, without it, it's nugatory. It's indispensable. That's Jefferson, Madison, many others as well. Necessary, number two, necessary means convenient. That's Alexander Hamilton and Chief Justice John Marshall. Now, mind you, Marshall said they can't just do whatever they think is convenient. It has to be kind of convenient to the powers delegated. Now, that doesn't really change the equation, because as everybody was warning, as we've heard a number of warnings just in this episode here, if you can twist anything into a convenience, they're going to find a way to do it. And that's going to end up with unlimited power. And then number three is somewhere in the middle. That is the Edmund Randolph view. Now, I think the real essential question is, who is right on this? I think if you're listening to me, you probably know where I'm leaning. But let's go to Edmund Randolph, because I think he gives us a real surprising answer on which one is correct, right in the Virginia Ratifying Convention. It ties back to what I was talking about, how to understand the original legal meaning of the Constitution, as James Madison was telling us, to understand how the people who gave it legal force understood it, the ratifiers, the people of the several states. Now, here's Edmund Randolph again, Virginia Ratifying Convention, June of 1788. He said, "I observed yesterday that I conceived the construction which had been put on this clause by the advocates of the Constitution was too narrow, and that the construction put upon it by the other party was extravagant. The intermediate explanation appears to me most rational." Short version is, all the Federalists who are saying it added no new powers at all, this is James Wilson, James Iredell, Archibald McLean, Alexander Hamilton, James Madison, and so many others during the ratification debates. Very influential people. They're just saying, he's saying their view of it, the advocates of the Constitution, the Federalists, are explaining it too restrictive. And he's saying the anti-federalists, it's just extravagant. This is not what it's supposed to be. But keep in mind, maybe he wasn't aware that Brutus was saying, I'm not actually trying to torture that definition. I'm just basically warning how it's going to play out. But Randolph is saying the middle ground, my ground, is the correct one. And he probably was right because he's one of the drafters. But again, the intention of the people at the secret conclave in Philadelphia has no impact on the legal meaning as understood by the ratifiers because they didn't know what was going on behind closed doors. I'm not even certain. I would think that they didn't even know that Edmund Randolph was one of the primary drafters of the clause in explaining it. Maybe they did at this point. I'm not certain. I think unlikely. But he's basically saying the middle ground is legally correct. And legally, in the tradition of how things have played out, Edmund Randolph was probably correct. But the kicker is he's pretty much the only guy who actually made that case during the ratification debates. And again, if we reiterate the fact that the original legal meaning of the Constitution is how the people who ratified it understood it. And if he's the only guy explaining it like this, and everybody else, and even Randolph himself, is pointing out that everybody else is explaining it far too limited, well, then that's the one that's legally binding. Here he goes a little further. He said, the former, referring to the Federalists, the former contend that it gives no supplementary power, but only enables them to make laws to execute the delegated powers. Or in other words, that it only involves the powers incidental to those expressly delegated. By incidental powers, they mean those which are necessary for the principal thing. So this is the absolutely necessary or the indispensable power argument. And he goes into a little bit more detail. Of course, this will be linked to in the show notes so you can read Randolph's full speech anytime. But he said if incidental powers be those only which are necessary for the principal thing, the clause would be superfluous. Mind you, Hamilton, a couple months earlier, was saying that the clause was superfluous. It's no point. It's just merely declaratory. Now, Randolph is saying with his legal training and his drafting of the clause itself that it wasn't superfluous. It did add a little bit more, but there was some gray area there. So I would just recap it like this. Again, if everyone who was arguing against it was saying this is going to give us unlimited power, and then the supporters of the Constitution are saying, no, this is much more narrow than that. It can only be necessary to the delegated powers, and that's how the people ratified it under that understanding, then Edmund Randolph's position is not the position of the Constitution for the United States. So that's my take, is that it's really the Jefferson, Madison, Federalist argument for the necessary and proper clause. That's the actual one, the legal one under the Constitution. I'm curious which one you think is correct, Jefferson, Madison, Randolph, or, well, the villains, Alexander Hamilton and John Marshall. Either way, this is not the kind of stuff we are ever taught in government-run schools. I never learned about any of this until I sought it out on my own. You're here seeking it out on your own as well, and I'm so grateful for that. But it's a huge part, because we're not taught this important stuff, it's a huge part of why we work so hard every single day to get this kind of information out to more and more people. And there is absolutely nothing that helps us do this work more than the financial faith and support of our members. It is necessary for us to be able to reach and teach more people. I got to do a little pun here and there. Necessary for us to reach and teach more and more people to get some financial support. And you can join us for as little as $2 a month over at 10thamendmentcenter.com/members. If you got a couple of bucks of that dirty government fiat, please consider throwing it our way. We also have annual, 5-year, and lifetime options. Again, 10thamendmentcenter.com/members. If you prefer to make a one-time contribution, that's 10thamendmentcenter.com/donate. I won't belabor the point any further, but I'd be extremely grateful for any consideration you can give to joining us or supporting us financially today. You can also help us spread the word by doing a bunch of stuff, especially on the mainstream platforms. The video platforms, the more percentage watch time you get, the better. So if it's 110%, for example, YouTube and other platforms will be more likely to show us to more people. Reviews on Apple Podcasts, any other podcast platform, hitting the like button, subscribing, getting notifications, comments, etc., etc. Again, I really appreciate your help in spreading the word, and all that stuff will go a long, long way. I really appreciate you being here. I hope you enjoyed this episode. I hope it made you think. I hope you learned something that's more important than anything. And I hope to see you next time here on the Path to Liberty.